A slender, silvery fish, sold for bait and canned as sardines, has the potential to play an outsized role in weakening the power of federal agencies to regulate vast areas of American life, overturning long-standing Supreme Court precedent in the process.
For 40 years, courts have generally deferred to the judgment of federal agencies when it comes to turning laws passed by Congress into detailed regulations designed to protect the environment, consumers, and the workplace.
They did so because of the precedent set in 1984 in Chevron USA versus Natural Resources Defense Council, which requires judges to defer to the reasonable interpretation of federal agency officials charged with administering ambiguous federal laws.
But as the court has moved to the right in recent years, the conservative majority has been less likely to invoke that ruling, which outside groups have long seen as giving unaccountable bureaucrats too much power.
Now the High Court is reviewing a pair of challenges to federal rules requiring commercial fishermen to pay for at-sea monitors, cases that could lead to the demise of Chevron. Much as the 2022 Dobbs ruling overturned the historic Roe v. Wade ruling and eliminated the nationwide right to abortion.
Both lawsuits are backed by conservative legal organizations, the Cause of Action Institute and New Civil Liberties Alliance, that have received millions of dollars from the Koch network, founded by billionaire industrialist Charles Koch and his late brother, David Koch.
The framework, known as Chevron deference, may sound like a boring academic exercise, says William and Mary law professor Allison Orr Larson, who specializes in administrative law. But the question of how much flexibility to give federal agencies to implement laws passed by Congress has enormous implications.
Supporters of Chevron, including environmental groups, labor and civil rights organizations, and the Biden administration, say Congress often writes broad statutes to give government experts the leeway to address emerging complex problems. Overturning or scaling back the legal precedent, they say, will hamstring federal agencies and shift power to the courts and Congress.
Solicitor General Elizabeth B. Prelogar, who is defending the precedent, told the justices in court filings that overruling Chevron would be a convulsive shock to the legal system.
Opponents of Chevron, in contrast, say the framework unfairly tips the scales in favor of government agencies in litigation challenging burdensome regulations.
While lower courts have relied on the Chevron framework in tens of thousands of cases evaluating federal rules and orders, the approach has fallen out of favor in the last decade with conservatives on the Supreme Court.
Former Solicitor General Paul Clement, who is representing the New Jersey fishermen, said in his court filing that it's time to officially call it quits at all levels of the judiciary.
To prevent overfishing and promote conservation, the Trump administration initiated a program in 2020 requiring Atlantic herring fishermen to carry monitors aboard their vessels during certain trips to inspect operations and track fishing limits.
A coalition of fishermen sued, asserting that the Magnuson-Stevens Act does not directly authorize the government to force them to pay for the $700 a day monitors on trips that often last several days.
William Bright, co-owner and captain of the 140-foot retriever based in Cape May, NJ, said that is his concern, not the broader concept of government monitoring.
Bright's worries center on the economics of his industry, where the profit margins are slim and the cost of paying for monitors could reduce annual returns by up to 20%.
The industry-funded monitoring program was short-lived, ending last year due to lack of sufficient funding. The fishermen were reimbursed for all costs. Bright and others behind the lawsuit, however, worry the plan will resurface and expand to other types of fish.
In addition to the New Jersey case, the court added the second, nearly identical one from Rhode Island to its calendar, presumably because Justice Ketanji Brown Jackson was recused in the New Jersey matter after serving on the appeals court panel that initially reviewed it before her elevation to the Supreme Court.
Liberal Justice Elena Kagan made a similar point when the court's conservative majority sharply limited the EPA's ability to combat climate change in a 2022 decision. Kagan wrote in dissent that the majority had wrongly empowered the courts, instead of Congress or expert agencies, to pass judgment on climate policy.
The herring cases are just one way the court is being asked to diminish the power of administrative agencies. This term, the justices have already held oral argument in a case challenging in-house legal proceedings used by the Securities and Exchange Commission and another questioning the funding mechanism for the Consumer Financial Protection Bureau.